Hi, everybody. My name is Eric Meisberger. I am a public services librarian here at Mount Lebanon Public Library. We're very excited to have you here tonight for this presentation. I'd like to thank our presenters and our friends from Pennsylvanians for Modern Courts. And without any further ado, I'm going to turn it over to Tom and let's get this party started. So over to you, Tom.
Thank you, Eric. Good evening, everyone. My name is Tom Bailey. I am the Pittsburgh Program Coordinator for PMC. My wife and I live in Verona. Pennsylvanians for Modern Courts is the only statewide, nonpartisan, nonprofit organization dedicated to ensuring that all Pennsylvanians can come to our courts with confidence that they will be heard by qualified, fair, and impartial judges. PMC in the community, we have several programs that we operate. One is called PMC Watches, and that is our Pittsburgh Bail Watch, where volunteers observe preliminary arraignments at the Pittsburgh Municipal Court building, and then they coordinate with us to record their data and their comments. We also act as advocates. We advocate for reform of our judicial selection and discipline processes. And we also have a program called PMC Shares, which is civic education about Pennsylvania's judiciary. That's what we're doing this evening. And we also conduct judicial election forums and programs. So if you'd like to know more about the candidates for election, consider that the next odd number year. And we conduct continuing legal and judicial education, which are ethics courses for judges and lawyers. As we begin this evening, should you have technical issues, please email us at the email at your screen, staff@pmconline.org. If you lose your computer connection, you may call one of the numbers on the Zoom link to allow you to join by phone. Tonight's presenters are discussing general legal topics. They are not giving legal advice. Should you wish specific legal advice, please consult an attorney of your choice. This program is being recorded, and the recording will be available after this evening on our website, pmconline.org, and then look for the link for resources, and you can watch the entire recording. Please put your questions that you wish to present to our presenters in the chat, and we will reach them eventually. Our presenters for this evening: Magisterial District Judge Wheatley. Judge Wheatley has worked at a consumer rights protection law firm, litigating cases across Pennsylvania on behalf of Pennsylvania consumers. Since 2004, she has served as both mediator and pro bono attorney for Allegheny County's Housing Court. Since 2007, she practiced with Papernick and Gefsky, focusing on civil litigation and real estate matters. In 19 years as a litigator, she has practiced in common pleas courts in over a dozen Pennsylvania counties and before the Pennsylvania and federal appellate courts. In November of 2021, she was elected the Magisterial District Judge for the district serving Mount Lebanon and Dormont. Presenter number 2, Eileen Yacknin. Eileen has been a staff attorney with Neighborhood Legal Services since 1977. She has worked in all areas of poverty law: housing, consumer, family, unemployment, and public benefits. Eileen has litigated a number of cases before the Pennsylvania Commonwealth, Pennsylvania Superior, the U.S. Bankruptcy Court, Western District of Pennsylvania, and the U.S. Supreme Court, which have resulted in significant positive impact for her clients at the Neighborhood Legal Services. Currently, Eileen is the Director of Litigation for Neighborhood Legal Services here in Pittsburgh. We have excellent presenters for this evening. Our agenda is broken into 2 parts. First will be what to know before going to court, and then there will be a time for question and answers. And then our second will be going to court, and a second time for questions and answers. So let's get started with what to know before going to court. Ladies?
All right, so I'm going to take the lead on explaining the hierarchy of the Pennsylvania court system. As you can see on this slide, the Pennsylvania court system is all under one umbrella known as the Unified Judicial System, with 4 levels. At the lowest level is the Magisterial District Courts, which is the court on which I was elected to serve. And also on that same level are municipal courts in places like Philadelphia County. Magisterial district courts hear civil actions where the amount in controversy is less than $12,000. All residential and commercial landlord-tenant matters initiate in the magisterial district court where the real estate is located. And then on the criminal side of the court docket are summary offenses, traffic citations, non-traffic citations, as well as the preliminary hearings and preliminary arraignments on criminal cases that happen in the district. Moving up the court system from its lowest level to the next level up are our county court of common pleas. Most court of common pleas are 1 county districts. There are a couple up in the central northern part of the state that are 2 county districts. Courts of common pleas are the original jurisdiction trial court for both civil and criminal matters in the Commonwealth, and jury trials and non-jury trials there. Tom, you can advance the slide if you want, kind of just as I move forward. I went to Court of Common Pleas, but we'll pop back to the Pennsylvania Supreme Court since that's the slide you have next. Pennsylvania Supreme Court is at the top level of our court system and has very little original jurisdiction. Most cases that go to the Supreme Court go up on a request for review that's formerly known as aliquotter. And I would say the statistics are that about 3% of the requests for aliquotter are granted in any given year. The judges, at least 3 of them, have to agree to hear a case, similar to how the US Supreme Court decides whether to hear cases. Judges to this court are elected for 10-year terms, and there are 7 justices. And incidentally, since we're attending a program led by the Mount Lebanon Library, the current Chief Justice of the Pennsylvania Supreme Court is a Mount Lebanon resident. We'll go on to the next slide, Tom. Those are our current Pennsylvania Supreme Court justices as of January 2022, when we had 1 new judge elected to that court. Or maybe that's not the current court. That's not the current court. Moving on to the intermediate appellate courts. At our appellate court level, we have 2 co-branches of the appellate court system. We have the Commonwealth Court and the Superior Court. The Superior Court has many roles, the primary one being appeals from non-capital criminal cases and civil cases. It is commonly known as the busiest appellate court in the country. In 2020, which is the last report we have, it processed or adjudicated nearly 5,300 cases out of about 15,000 applications for review. There are 15 judges on the Superior Court elected in statewide elections, and they also serve a 10-year term. The Commonwealth Court is the kind of co-equal appellate court in the Commonwealth, and that hears cases where the Commonwealth or Commonwealth agencies are a party on direct filing as opposed to an appellate jurisdiction, and then also appeals from decisions made by state agencies, local government, regulatory agencies, and it also hears appeals in things like eminent domain matters and other governmental decisions. There are 9 judges on the Commonwealth Court, also elected for 10-year terms. And based on the last triennial report that's available, it handles approximately 4,000 cases a year. And then moving down, I started to talk about the courts of common pleas. There are 67 districts in the Commonwealth for the courts of common pleas. And like I said, some are single county and some are multi-county. Judges to the courts of common pleas are elected for 10-year terms. And the number of judges for each county is based on the population size of the county.
Judge, if I could, just a minute, I have pictures then of the Superior
Oh yeah,
Court.
go ahead.
Superior Court. Again, this is not the newest picture. It does not have the newly elected justices. And then the Commonwealth Court. And just one for folks, when we have in-person sessions, both the Pennsylvania Supreme, the Pennsylvania Superior, and the Pennsylvania Commonwealth Court meet in Pittsburgh if they're in person at the City County building.
And those
Ready for the next
proceedings
slide?
are open to the public. Yeah, absolutely. Go ahead. All right. And so Allegheny County is what's called the 5th Judicial District in the Commonwealth of Pennsylvania. And the Judicial District is presided over by our President Judge Kim Berkeley Clark, and then the court is divided into 4 divisions. And you can see on the slide the judges that are assigned to those divisions and the cases that each of those divisions hears. Relevant to tonight's proceeding, landlord-tenant disputes that originate at the Magisterial District Court level on appeal are under the civil division umbrella, which is where the civil housing court and arbitration divisions kind of operate under. So that's what our county court system looks like. All right, and now we're here to the kind of meat of what you're all here to learn about tonight. Eileen, do you want to start covering some of the rental housing topics, and I'll pipe in as.
Great, good. So, yes, Judge Wheatley and I may have different perspectives because I represent tenants, and Judge Wheatley is the decider of the disputes between landlords and tenants, which are what I litigate and what are heard before Judge Wheatley's court. But before we get into how those cases are litigated, get a basic idea of what the topics are that are litigated in those landlord-tenant disputes, and those are cases in which there exists a landlord-tenant relationship. And what is that? If there is an agreement that somebody who does not own a property has the right to possess property through an agreement in which rent is paid in order to be able to possess that property. Every landlord-tenant relationship has a lease agreement, whether or not that lease agreement is in writing. But best practice, of course, is that the landlord-tenant relationship is defined by a written lease, because otherwise many terms of the lease will not be expressed, and then it's basically a he said, she said argument about what is in the lease. So having a written lease is probably the most critical rule of thumb for anybody wanting to enter into or choosing to enter into a landlord-tenant relationship, so that both sides have an idea of what, or know, and can understand what the responsibilities and rights and the duties are between the two. So next slide there. Generally, the first paragraph of this says what I said. In Pennsylvania, actually, a lease of a term of more than 3 years must be in writing by law, or else it will not be considered enforceable. And in Pennsylvania, there's a special law that requires that all contracts, including leases, which are a type of contract, must be written in plain language. It would be illegal, actually, to have a lease like that includes legalese and jargon that is not understandable to a person who who's not a lawyer. And of course, clarity is critical in every lease. The rule of thumb for deciding a dispute is, what does the lease say? And if the lease is ambiguous or it's not clear enough, then the judge must interpret what the lease conditions, what the lease terms are, and So of course, the clearer a lease is, the easier it is for a judge and for the parties themselves to understand what those terms require. Next slide. So in our state, in our area of the state, actually, and I don't know that this is true for into all of the state, but in our state, most leases are generally, written leases are generally for a term of 1 year, but often leases are month to month. And month to month means that either party has the right to terminate the lease at the end of the lease term, which could be as short as 1 month. Or if you have a common lease of 1 year, then of course the termination or renewal could be at the end of that lease term. The next paragraph, there's a typo. There should be a renewal clause in every lease, which will then clearly state how a lease must, what is required in order to renew a lease. That's supposed to be renewed. And then that will then determine what the parties must do in order to renew a lease. If there is no renewal lease clause, then the law will imply that a lease renews for the same period of time as the original lease. So if a tenant has a 1 year lease and there's nothing in the written lease that says that when the lease ends, the lease will now become a month to month lease, which is often what's in a written lease, then that lease will continue for the same term of 1 year. Leases can't be changed. Even the terms of the amount of rent can't be changed within the original lease term unless both parties agree. And what this means, additional consideration, means there has to be something that's given to each party in exchange for what is given by the other party. So a landlord, for instance, can't in the middle of a lease term raise the rent, but that could happen upon proper written notice at the end of a lease term. And if a lease expires and it's not renewed, and the landlord chooses not to renew it, then a landlord has a right to evict a tenant, even if there is no good reason, they call it without good cause. This is, from my perspective, a really critical deficiency in landlord-tenant law in Pennsylvania, because as I've been seeing lately, we are getting many tenants who have lived in their rental housing for dozens of years and long decades, and all of a sudden the landlord says, I want to evict you for various reasons, but it could be no reason at all. And if the lease has expired, then a landlord, no matter how long that person has lived in the rental unit, the landlord in Pennsylvania has a right to terminate that lease and evict the tenant if they don't move. But that's what the law is in Pennsylvania right now. I don't know if you want to comment or put in that.
I think that you're right. I mean, when it comes to end of term, those are, from a litigation standpoint, nearly impossible to surmount for a tenant and pretty easy to present for a landlord, just based on how the law exists in Pennsylvania.
Yeah. From a tenant lawyer perspective, I could say that in those kinds of cases, we can't ever tell our tenants that we'll be able to allow them to remain in the house, in the premises much for long, but we do know how to litigate in a way that would give, hopefully, tenants the opportunity to find new places to move to.
Yep.
There is in Pennsylvania, well, actually, this is also, there's a couple of typos there. It doesn't really mean the statutory side. It's a federal law that requires that lead paint be disclosed, the existence of lead paint, and for every lease. So just for landlords to know that it's required, to provide the proper notice to tenants who are moving in. And the last sentence is that the lease may not be valid unless this information is provided. But this is obviously a fairly recent requirement because of the seriousness of the consequences of having lead paint in a house where young children especially live.
Yeah, and with respect to this lead paint disclosure, this applies whether you rent 1 unit or 100 units. Like, you know, if you're just renting out your garage and you've got a lease, you have the landlords have this obligation. And I feel like a lot of small kind of, you know, just renting something on the side as opposed to rental management companies often fail to comply with this disclosure requirement.
Yeah, and I would say that if something happens to a tenant as a result of having lead painted and not being disclosed, could be very serious consequences to penalties, as you can see there. So anyway, okay.
Okay.
Next slide, Tom. There we go.
Yeah, so utilities, you know, who pays the utilities is always should be specified in a lease. We generally, if a landlord requires it, then the tenants will be, if the tenants are responsible for the utilities, then generally the tenant has to open up accounts in their names for with the respective utilities, and that's easily done with gas and water. I guess in the good old days, we used to have telephone accounts, but now everybody has their own cell phone anyway. I'm sorry, gas and electricity, not gas and water, but gas and electricity. Those are opened up in the names of the tenants unless the landlord chooses to pay those utilities. Problems often arise with regard to water and sewage, and there's different problems and different responsibilities if the water and sewage utilities are provided by a municipal authority or a private corporate company that is regulated by the Public Utility Commission. And they're called public utilities because they're regulated by the PUC. And for example, Pennsylvania American Water is a public utility that's regulated by the PUC. But the West Penn Joint Water Authority and even the Pittsburgh Water and Sewage Authority are not, well, I'll go with West Penn first. West Penn Joint Water and Sewage Authority is a municipal authority. It's a municipal utility. They're not regulated by the PUC, and there's different rules. PWSA for Pittsburgh used to be a municipal authority, but because of all of its problems a few years ago, the state legislature decided it needed to be regulated by the PUC. So now Pittsburgh Water and Sewage Authority, even if it's called authority, which usually means a municipal entity, PWSA is now a public utility, or at least under the auspices of the Public Utility Code. But one big difference is that if it's Pennsylvania American Water, a public utility regulated, then it's then if there is a delinquency in the if somebody doesn't pay the water bill, there is no lien on the real estate. But if it's a municipal authority that is owed the money for sewage, that is almost always, and to my experience, all in this area always is a municipal utility, then failures to pay sewage or sometimes the water, depending, there will always be a lien imposed on the real estate itself. And so landlords often want to make sure that those bills are paid, and often then will include that payment incorporated as though it was part of the rent, or demand that the tenant pays the landlord directly for that, to reimburse them for those services. But if there is no meter for individual tenants and you're in a multifamily unit, then whether or not it's then you can't, the tenant, there's no way a tenant can open an account in their name. And but if it's a municipal authority that's being paid for the water or sewage, then the landlord can just charge each tenant regardless of what the actual cost is to the landlord. But of course, it would be, the fair thing would be to charge fairly between the tenants. If it's a regulated company, then the landlord is not allowed to charge more to the tenant than what the tariffs are that allow. This is probably way too much. Generally, if the biggest rule about utilities that would help, that are important for tenants, besides whether the account can be in their names or not, or should be, is that a landlord generally is not permitted to charge a single tenant, or to put for a common area, for instance, electricity in the hallways of the lobby of the building, or for the basement electricity or the basement water if other tenants use that as well. So that's enough.
And just specific to Mount Lebanon for people who live in the area, Pennsylvania American Water is the water provider, but our sewage is billed directly through the municipality and paid to Jordan tax, and therefore it's a lienable debt, but not the water.
Eileen, does PUC stand for Pennsylvania Public Utility Commission?
Yeah, yes.
Okay.
Yeah. Do you want to do the next few?
Sure. Yeah, I'll cover the next few. So in Pennsylvania, we have the landlord-tenant law, which is helpful but not great in terms of setting forth all of the rights and obligations of landlords and tenants. It could use an update, to be frank. But when it comes to basic tenant rights, tenants have the right to exclusive possession of the property that they have rented. They have a right to a habitable residence, which, is the basic habitability is defined generally as providing you your basic needs to live: potable water, electricity, windows and doors that lock and close, working utilities, a working sewage system. And you have the right to quiet enjoyment of the residence, which means, you're not being unreasonably disturbed by your neighbors, or unreasonably having a landlord who's unreasonably demanding access to your rented property. When it comes to exclusive possession, you do have an expectation of privacy within the residence. You're able to come and go without an issue, meaning you have free access to your property, including, secured common doors. The landlord isn't permitted to change the locks without notice, or deny you access for any reason. And the landlord is only permitted access to your property upon reasonable notice for inspection, or if there's an emergency. Obviously, you know, like water leaking from the ceiling, they wouldn't be required to give notice, but for regular routine maintenance and requested repairs, they'd be required to give you notice. And most leases set forth the amount of notice required. And beyond that, when it comes to exclusive possession, landlords are absolutely prohibited from any sort of self-help to take possession of the property, even if the lease is expired, even if they've started eviction process, even if they've given you notice of their intent to seek possession of the property. They cannot, under any circumstances, lock you out of the property until a court has issued an order granting them possession and the sheriff or a constable has posted notice of their right to evict you.
Let me just add, I wish it really was cannot. It certainly is, they must not, but unfortunately there are landlords who ignored this and do that illegally, but that's when we get involved also. Yeah. And the other thing I wanted to say is, it just dawned on me that one of the few provisions of the landlord and tenant law in the statute in Pennsylvania provides that a landlord is not permitted to restrict a tenant's right or to prohibit a tenant's right to have guests. Landlords might have a right to restrict, like how long a guest remains in a property, because if a guest stays for a year, then it's obvious they're not really a guest. But a landlord is not permitted to prohibit a tenant's right to have guests.
And therefore, a landlord couldn't, well, may try, but the courts should not allow a landlord to seek possession or terminate a lease because a tenant has had 10 people in the property, you know, for a party or for, you know, an overnight stay. If it's prohibited under the law, that can't be a legitimate basis for possession of the property. Next slide, Tom. All right, so I briefly touched on this warranty of habitability. It's an implied warranty, whether stated in the lease. It can't be waived under any circumstances. It requires that a landlord comply with municipal building codes and regulations, ensuring health and safety. It must be clean, safe, and fit for human habitation. The breach or the alleged breach of the warranty of habitability is the most often raised defense or counterclaim to a landlord's eviction action, although sometimes they're brought on their own by landlords. But in order to bring a claim for this breach, you first have to, or tenants first must give the landlord notice of the problem and a reasonable amount of time to fix it. And what is considered reasonable is really a case-by-case determination based on the kind of problem that has been raised. And then there are a variety of rights a tenant has if the problem remains unresolved after a reasonable amount of time. They can give notice and terminate the tenancy and move out. They can stay and withhold rent or a portion thereof. They can ask for a rent abatement. They can do the repairs and deduct the cost from the rent due, or they can bring an action and sue for damages, specific performance, or injunctive relief. And those claims and those rights that the tenant has are really related to the landlord's obligation to maintain the property and not defects caused by the tenant. Would you agree with that, Eileen?
Yes. Yeah.
So if a tenant makes the property not fit for human habitation, the tenant then does not have those rights I just enumerated for remedy. Next slide. Eileen, you want to cover this one?
Okay, so right to quiet enjoyment is basically that the landlord has a duty not to interfere with the right of the tenant to that exclusive possession. And as Judge Wheatley already said, it's like you can't harass a landlord can't harass the tenant in numerous ways that people often complained about, and it's essentially that landlord can't demand immediate entrance into the property. Landlord certainly can't go into the property without permission of the tenant, because it really is the tenant's right to possess that property. Once a lease exists, it's not the landlord's right anymore. Of course, emergencies are an exception. And what this right gives is to the tenant is essentially the right to break a lease and move out if the landlord violates this obligation, and not be liable for the rest of the rent under the lease as a result of the violation of that breach of the right to quiet enjoyment. Okay, next slide. Questions? Are landlords required to charge the same amount of rent for comparable size units? I'll try, and Judge Wheatley, maybe you can see if we would agree or not. I think that there's very little restriction on what landlords have the right to do.
Yep.
In Pennsylvania, and except in one situation where we'll talk about this at the end of the slides, is I think, yes, you could do it. The landlords have the right to do that, unless it could be shown that doing so is a result of illegal discrimination on the basis of all the prohibitions against discrimination for different groups of people, and we'll talk about that, but race, gender, ethnic background. So that would be illegal if that's why a landlord is, and it can be shown that that's why a landlord is charging somebody else different rent.
Yeah, but I absolutely agree with that. And in circumstances where that's not the case, there's no evaluation done by the courts in whether or not the rent was reasonable or appropriate if it was in the lease. If it's contractually agreed to, the courts aren't asking the landlord whether they charge the same amount for the apartment next door. And there'd be no expectation that they would have to, because, when you think about it, apartments in a multi-unit building might get updated at different times. And so one unit that's been occupied for 5 years might not have been touched, but the next door unit that's identical might have just been completely rehabbed after a tenant vacates. And so under those circumstances, it would be reasonable and frankly expected that a landlord might charge more for the newly done apartment, even though it's identical to its neighbor.
Okay.
Can I ask a
Now the
question?
fun part. Ms. Miller?
Yes, can I ask a question, please? I moved into a new building and there was an empty lot next to my window, 20 feet away. And they put a dog park in. Now, come summer, that's going to be really noisy and it's going to be really smelly and there's probably going to be vermin. And are there no regulations that allow or disallow that kind of use of property?
It depends on what jurisdiction you're in.
I live in Pennsylvania.
Each municipality has its own rules with respect to zoning and permitted uses for lots.
All right, well, and I did go to the council and they said it's because it's their property, they can do what they want on it. But that's gonna make it, unpleasant when the warm weather comes. I won't be able to open windows. And another question, does the landlord have to warn you if he's not gonna really renew your lease? Or does he just say, be out by Monday?
Well, the landlord actually will be talking about that. There is a either whatever notice that a landlord has to give not to renew a lease is in the lease, how much notice. And if it's not, then the Landlord-Tenant Act does prescribe a certain notice before you can be taken to court. It's not much, you'll find out, but it's at least something before they can sue you for the end of the lease.
All right, I see a question from Gabby asking to explain what a lien is and how it works. And I'll be happy to take that, since the last 14 years of my practice has been real estate law and transactions and dealing with lien letters. So the simple explanation of what a lien is, it is a debt that attaches to the real estate, meaning that not only may the debtor have a personal obligation to pay the debt, but the real estate has an obligation to pay the debt. And the way that is enforced is by it being required to be paid upon the sale of the real estate, and the person holding the debt having the ability to take the property through a sheriff sale or a tax sale to satisfy the debt. It's like a mortgage is a lien on the real estate, just like an unpaid municipal water bill or sewer bill is on the real estate. Generally speaking, liens attach to the real estate and are the obligation of the owner of the real estate, as opposed to a tenant residing on the property.
With that, can we proceed to the next section, please? And then we have another question and answer session.
Yep.
I'll do this. Well, I'll start.
Go ahead and start, Elaine. Eileen, sorry.
Although Judge Wheatley did say these words, and I will not, and we have to say them over and over again. There is no self-help allowed in Pennsylvania, probably nowhere in the country, hopefully. But if a landlord wants to evict a tenant, you have to sue. The landlord has to sue, and otherwise it's illegal. And the courts, the judges in the courts of Allegheny County, at least, and almost every county, I'm sure, take this particular prescription very seriously. Landlords are not permitted to evict a tenant or do other types of self-help, actually, to try to get a tenant out, like, for instance, shutting off the water, or in a case I just had, refusing to repair the furnace because they wanted the tenant out. That's illegal. If you want the tenant out, you have to sue. Next slide.
Next one.
Next slide, Tom.
Sorry. And so here's a summary, though, in answer to that other question as well, the prior question, that Pennsylvania law does prescribe how much notice you have to give, the landlord has to give warning before a lawsuit can be filed. But I'm about to say unfortunately, unfortunately, Pennsylvania law also says that if the lease itself says that this advance notice is waived by the tenant, then there is no obligation for the landlord to provide that notice. It's called a notice to quit. As some people have indicated to me, not to give notice would not, to waive notice is not a great practice, and the notice that a landlord has to give as a warning is not that long anyway. Recently, for federally subsidized properties, which are owned by HUD or which are regulated by HUD, there is now a requirement that those tenants must be given 30 days advance notice by a landlord if a tenant is going to be evicted for non-payment of rent. The state law says that otherwise, if it's not a HUD subsidized property and the reason for eviction is non-payment of rent, then the notice must give 10 days notice. If the reason for eviction is for any reason other than non-payment of rent, meaning another type of breach, and that can range from destroying the property to having a dog or anything in between, or for at least expiration, 15 days advance notice must be given, and it must be in writing. Pennsylvania law says it must be in writing and delivered by posting, by personal delivery to the tenant, or by posting on the door only. Those are the only ways that the law allows for that warning notice to be given.
Eileen, would you consider sliding notice under the apartment door personal delivery?
Oh, well, I guess I would try to argue it, and I don't think that would work. I don't know what judge what you would do. The thing which I'm seeing more though, which I do wonder, and I certainly would vigorously challenge, is text noticing email. And I don't, so far the state legislature hasn't changed this old law, and the law must be, there's court cases that say this law must be interpreted strictly. And anyway, that's what I would argue.
Yeah.
That's good to know.
Yeah, and I think, text notice, you would have the same analysis about an email delivered notice.
Yeah.
Right. The arguments would be the same against that being effective notice.
Mm-hmm.
All right, next slide.
Next slide. And you can.
I'll take it, whatever it says.
Okay.
All right, so after receiving a notice to quit or an eviction notice, the tenant has a couple of options. They can follow the notice and move out, cure the problem that caused the notice to quit to be sent, whether that's unpaid rent, or some sort of other violation, like having a pet you're not permitted to have, or letting somebody move in that wasn't permitted to move in, or you can just stay and force the landlord to sue you to take possession. So if you do option 3, the landlord has to file a possession action with the court of appropriate jurisdiction to start the eviction process, and the filing of that would take place at the Magisterial District Court that has jurisdiction over the real estate where the property is located. It wouldn't be necessarily where the landlord lives. It's where the property that you live in is located. And the landlord would, go ahead.
I'm just, could you switch the slide, Tom? Because you probably should ask you to continue, Judge.
Oh, sure. Okay. Well, I was still covering the one beforehand. I was about halfway through.
Oh, I'm so sorry. Go back.
That's okay.
Okay.
And yeah, so, okay. Yeah. So I've covered everything now. Okay. I see the notice to quit. You, Eileen, you already talked about that, so we can move forward. Okay. So, the landlord would either go to or mail the complaint for possession to the magisterial district judge or court where the property is located. And once that complaint is filed and the filing fee is paid, notice of the hearing is served on the tenant by constable. It's generally served personally by the constable. by a constable, which is like a formal elected process server that gives the date of the hearing. Most magisterial district courts require that the tenant give notice of their intent to defend, but not all courts do. And at the hearing or before the hearing, the tenant could file a countersuit that would include things like breach of warranty, of habitability, or whatever other claims the tenant may have against the landlord. The hearing is scheduled and would take place before the court, and the court is required to issue a decision and put it in the mail within 3 days. Whatever decision the district judge makes is appealable to the Court of Common Pleas. If the judge enters an order of possession, the tenant has to file an appeal within 10 days. And if it's a judgment for money, the tenant has to file an appeal within 30 days. If a judge enters an order for possession and money, you better file your appeal within 10 days, or else you have lost your right to appeal the possession part of that order. Those appeals are filed with the Court of Common Pleas, and in Allegheny County, they are automatically, upon the filing of the complaint in the Court of Common Pleas, scheduled for an arbitration hearing. And those notices with a date and time and location of the arbitration hearing are sent out by the court's Department of Court Records. And those arbitration hearings are scheduled to take place before a panel of 3 arbitrators, all of whom have been specially appointed to serve as landlord-tenant arbitrators. And it has been my experience in since 2004, when I moved to Allegheny County, that arbitrators deliberate as soon as the hearing concludes and make a decision immediately, and it's docketed by the end of the day. At least that's practice. Whether they're required to do that by rule is maybe a different story. You have 30 days from the date of the decision to appeal a decision from an arbitration panel. You don't have to state a reason for the appeal from the magistrate or for the appeal from the arbitration panel. You are just given an automatic right to appeal. I used to advise clients that you could appeal if you didn't like the color of somebody's tie and not have to explain why. Or you didn't like the color of the drapes, or the room was too cold. You don't have to have an actual legal argument for an appeal. An appeal from arbitration is scheduled for a trial under the housing court judge's scheduling jurisdiction, and that would take place before a judge or a jury, depending upon whether a jury trial has been demanded by the parties. Go ahead, Eileen.
I'm just going to add one thing that's interesting about this procedure is that the reason there are so many appeals is because none of these, with the magistrate judge or with the arbitrators, there's no court record of the proceedings. The evidence is not recorded. There's no transcript. And so when an appeal is allowed, then the appeal is what's called de novo, meaning you get to forget totally what happened at the initial hearing with the magistrate judge, and the landlord has to start all over again, proving the case, and the tenant has to start all over again, responding to that. And at arbitration, similarly, there's no recording of what happened, at least officially. And so therefore, the next appeal to a judge starts all over again. That's called de novo, starting all over again. And actually, even though the slide says it's that the third bite at an apple is before a judge, that's most of the time that is the case. But the Pennsylvania Constitution requires that every litigant have a right to a jury trial. So even in landlord-tenant cases, this third appeal could be if requested, before a jury.
And the last sentence on this slide deals with what's called a pay and stay judgment. At the magisterial district court level, judges have an option to enter a curable judgment for possession, which essentially means that up until the time the constable comes to lock you out, if you have the right to pay the money judgment to stay in possession of the property. So if a landlord sues a tenant for possession based on non-payment of rent, and the district judge enters a judgment for possession and a money judgment of $3,500, the tenant can hand the constable $3,500 the day the constable comes to evict the tenant, and the tenant gets to stay. Generally speaking, that's a judgment option available to tenants the first time a landlord has to sue them for eviction based on non-payment. But if a tenant is habitually sued for possession based on non-payment, that option is no longer available to them. Next slide. All right, so I think, yeah, so we covered 10-day appeal period from the magistrate court's order of possession. So on the 11th day, the landlord can come and request an order of possession, where the constable would then come and post a notice of the date of eviction. And then the constable would come back on that eviction date, and the landlord is generally instructed by the court to appear at that date and time for the eviction and have a locksmith available to change the locks and make arrangement for storage of left behind personal property. If the tenant loses at the district court level, and there has been a judgment entered for non-payment of rent, on appeal, the tenant may be required to deposit their ongoing future rent into the court's escrow during the appeal proceeding, kind of as security for the fact that you are remaining in possession. And if those required rent deposits are not paid on time, there's a process to allow the landlord to take possession even while the appeal is proceeding after required notice is given. But if the landlord loses, meaning the tenant wins at the district judge level, and the landlord files an appeal, that obligation to pay rent into escrow is not part of the appeal, though obviously under the lease and while in possession, the landlord would still have, or the tenant would still have a rental payment obligation, and it would be paid directly to the landlord. Next slide, Tom.
Okay. I'll do this one. If a landlord or a tenant, actually, rereading this, I realized that it's a little bit not accurate. If a landlord loses and wants to file a decision, or I'll say this way, if a landlord or a tenant wants to appeal to the Court of Common Pleas, they first must file what's called, with the Court of Common Pleas, a notice of appeal. The landlord is then obligated to file a new lawsuit in the Court of Common Pleas. So only a landlord must file a complaint. A tenant doesn't file a complaint. A complaint means lawsuit. So if a tenant files an appeal by filing a notice of appeal, then the court will direct the landlord to file a new lawsuit, a new complaint in the Court of Common Pleas, the housing court. And again, if the landlord files the appeal, then the landlord will also have to then later file the complaint. The rules about filing, responding to complaints are that the other side, the tenant, in this case will always be the tenant, will then have to file a written response to that lawsuit within a certain period of time, or risk losing automatically that case. So again, if it's the appeal time is there. This is, and just wanted to point out that for the last couple of years, there has been a housing court help desk where landlord-tenant matters are filed, and the clerks there will help litigants, especially those who don't have lawyers, concerning these kinds of matters. They have forms there to fill out, and and they can advise people. They can't give legal advice, but they can offer the proper forms or what options might be available.
And they are so helpful. I feel like since the creation of Housing Court and the placement of this Housing Court help desk in the Department of Court Records, it's just made the process a little less scary for unrepresented parties. Walking into Department of Court Records down in the City County building can be very intimidating for people who have never been there before. And the staff who runs the Housing Court help desk, I feel really, they know their stuff and are doing a great service.
Yeah, I double ditto that.
Yeah.
Sure. Next.
All right, I'll cover this. I wrote a memo on this statute right after it was after the statute was passed for the landlord group. It's the apartment, whatever, association. That's the word I'm looking for. So there is a statute or a section of the statute within the landlord-tenant law that deals with what we call abandoned personal property. So if you as a tenant move out, either because you've been evicted or you just willingly move out and leave items of personal property behind, the landlord-tenant law specifies very specifically what the tenant and the landlord have to do in that circumstance, unless it's been waived in the lease, which is, another right that we would recommend not waiving if that's something that can be negotiated. But if you haven't waived it after the tenant is evicted, or if the tenant moves out, the tenant has 10 days to contact the landlord to indicate their intent to get their personal property. The landlord then must keep the tenant's property for those 10 days. They don't have to keep it in the unit, but can move it to a common storage area or to a storage unit. And the landlord has to keep those items for up to 30 days, but may charge the landlord the cost of storage for that 30-day time period. Now, obviously, if the landlord has not incurred any costs for storage, there's no appropriate charge to the tenant for storing the personal property. If the tenant fails to contact the landlord within those first 10 days, under the Act, the landlord has the right to sell or dispose of the tenant's personal property after the 10th day. So really the onus is on a tenant who moves out or is evicted and just doesn't have the capability to move, a furniture or a dresser or the clothes in your closet or your baseball card collection or your antique doll collection. If you want your stuff, you really have to stay on top of it and make sure you get in contact with your landlord within those first 10 days to give them notice of your intent to come claim your property.
Next one.
Eileen, you want to cover this one?
Sure. So then we have the other remaining item for after a tenant leaves is the return of the security deposit. First of all, security deposits can only be, the total amount can only be up to 2 months rent. And at the beginning of the lease, and only 1 month's rent after the first year, although I don't know of any landlord that returns that security, that 1 extra month after the first year. Tenants just don't know to ask for it. The best practices for tenants to be able to obtain a return of a security deposit is and it's required in order to avail themselves of a protection by the law, is that tenants must make a request in writing and provide a forwarding address to the landlord when they leave the property. It said, this is where I want you to return the security deposit. A landlord then has 30 days to either return the security deposit in full or to provide a letter stating specifically why the deposit is being withheld to pay for damages or unpaid rent. And pay and put in that letter either the remaining balance or showing why the security deposit is being kept entirely. And if the landlord does not follow that process, after the tenant gives that notice, then there is a statute that allows the tenant to sue the landlord for double the amount of the security deposit. And it isn't critical. It's helpful, at least for both parties, if you do a final walkthrough inspection together and take pictures and but to show each side's version of what the conditions are. So if it has to be disputed later, there's some evidence of that.
Yeah, and even if the landlord doesn't agree to do a walkthrough inspection with the tenant, best practices for tenants on the front end of a lease and on the back end are to take pictures of the condition of the property before you move your items in, and take pictures of the condition of the property after you move your items out, so that if and when there's a dispute about how a tenant left a rental unit and it goes to court, you have proof from your perspective of how you left the property. And same goes for the landlord too. Take pictures before you have a tenant move in, and take pictures when you have a tenant move out.
Right.
You want to cover this?
Okay, so the anti-discrimination law, it's a federal law, and it's also a state law, and there's also in Allegheny County, I don't know what they call it, rule or law, and Pittsburgh an ordinance. There's no discrimination on for any of these reasons is permitted, and there are. There's basically just, if a tenant can show that a landlord has discriminated illegally for these reasons, whether or not the landlord has already accepted the tenant, and then there's some discrimination in the way that the tenancy is conducted, or even if the landlord chooses to evict a tenant and after they, for instance, find out that the tenant perhaps is gay or something, then the complaints, lawsuits, or either administrative complaints with the with HUD or the specific commissions, the Pennsylvania Human Relations Commission, the Pittsburgh Human Relations Commission. I think Allegheny County also has a human relations commission. Complaints can be made, and the landlord can be sued for damages for violate, and also hope perhaps even being required to maintain a tenancy or take action that would protect the tenant if the illegal activity can be shown. So that's essentially that.
Eileen and Judge, could we do this slide? Then I'm going to suggest we skip ahead to get to resources and then close with questions. We're at about 8:10 now.
Sure, I'll cover this one quickly.
Please.
Both Magisterial District Court offices and the Housing Court downtown have forms available, and obviously staff available who can answer procedural questions, but can't give legal advice. So if you're asking the court, what's the best course of action, or what should I do here? All that the staff can do is tell you procedurally what's the proper, what's permitted under the rules governing the court. And when it comes to filing with the court, providing as much information as possible upon filing is always best practice. Name, address, telephone number, details, filling out every line of the complaint. The landlord-tenant complaint, both in the Magisterial District Court level and in the Allegheny County Housing Court landlord-tenant complaint form, are kind of fill in the blank, check the box forms. So they make it pretty easy to navigate it without a lawyer. But just know the courts cannot give any legal advice.
Yeah. To that end, if for tenants at least, and if tenants meet our eligibility requirements, Neighborhood Legal Services is available to give legal advice and often legal representation. We can't represent all tenants because we don't have large enough staff to do that. But we definitely will give legal advice even for people who are not eligible for legal representation. But I can't stress, first of all, I really admire the magisterial district court judges because you all deal with people who don't have lawyers coming to court and trying to express how to address disputes and having to make decisions without perhaps some of the sufficient information that would help the judges make decisions. But if it's possible, both landlords and tenants, I think, really need the help of attorneys. Even I actually, as a tenants lawyer, know that I can actually, because I know what I'm doing, I can often win a case against the landlord because the landlord doesn't know what to do the right way to win a case. And so landlords, as much as tenants, it behooves both to at least get some advice before you go.
Sorry, we're skipping these. Eileen just spoke of Neighborhood Legal Services. Here is the link to their website and a contact phone number.
Oh, okay.
We also want folks to know that you have access to the Allegheny County Bar Foundation Pro Bono Center should you seek legal representation. One more. These are websites that give more access on landlord-tenant issues. And again, this has been recorded, so you can come back and watch this recording and get this information if you wish. Could we take, I think there's another question in the chat.
Yeah, I think, Joyce, the answer to your question is there's no law that would require the landlord to evict the noisy tenant that would force the landlord to evict. But what a noisy tenant would give a neighboring tenant the right to do is terminate the lease for breach of the right of quiet enjoyment. So, the short answer to your question is there's no requirement that the landlord do that. But failing to do so may be a breach of the neighboring tenant's lease with the landlord.
Yeah, that's a good answer. You have to look at the lease. If it's a written lease, then everything about what a tenant is required to do is in the lease. And so if there's nothing in the lease that says tenant must, now there are provisions in some leases that say tenant quiet hours, tenant must not be loud to disturb the neighbors. And if there was that kind of a clause in the lease, then you look at it's a contract and you could say, yes, they are violating the lease by doing that. But otherwise,
yeah, but the question becomes what's loud, right? And what's causing the loudness? Is it hardwood floors upstairs and someone walking around in heels, or is it tile floor and a baby running across the floor? Those sorts of subjective alleged breaches are really hard to deal with within the court system.
Yeah.
Okay. Thank you to MDJ Wheatley and attorney Eileen Yacknin for taking their time to share with us tonight. Thank you to Eric Meisberger and the Mount Lebanon Public Library. Just to notice that we have another session, April 21st, PMC, and the topic is how to administer an estate. PMC has our PMC watches with the bail watch, for instance, and PMC shares as a program like we did for this evening. That is it.
Thanks, everybody.
Thank you very much.